Hi, my name is Joe Gufford and I'm an attorney in Stuart, Florida. I primarily practice in the area of family law, which includes divorce, paternity, child support, alimony, equitable distribution, and just about any other area of family law that you can think of. The purpose of my video today is to talk about divorce in Florida. First of all, in order to file a divorce in Florida, you must have lived here for at least 6 months prior to the date of filing. That means you have to be a continuous and permanent resident of the state of Florida for 6 months preceding the filing of the case. The other grounds is that the other party has been a continuous and permanent resident of the state of Florida for 6 months preceding the date of filing. Now, let's get to the next issue. What are the grounds for divorce in Florida? I'm sure that you've probably heard that Florida is a no-fault divorce state. Essentially, what that means is that the judge doesn't really care as to the reason why you're getting divorced. The judge simply wants to hear that your marriage is irretrievably broken. Not why your marriage is irretrievably broken, not if it is, not that you were a good husband and she was a bad wife, or she was a wonderful wife and you were a terrible husband. The judge really doesn't care about the reasons why you're getting divorced. Now, while that may be important to you personally, and it's certainly a very, very important decision to make, that in Florida we are a no-fault divorce state, which means it really doesn't matter too much as to why you are getting divorced. Now let's explore that issue though a little bit deeper. In some situations we are dealing with adultery, and in a fault-based state, as to why you're getting divorced, that could be a very, very important factor. In Florida, it's not such an important factor. However, it can be a factor when we are looking at, for example, dissipation of marital assets in furtherance of the adultery. The adultery is admissible not to show the irretrievable breakdown of the marriage and the grounds for you getting divorced, but rather to show that assets were dissipated in furtherance of the adultery. So examples of that would be, for example, husband has a stripper girlfriend and spends $200,000 on a new condo for her. That would be admissible adultery, not for the purposes of dissolving your marriage, but rather for the purposes of showing that marital assets were dissipated in furtherance of the adultery. The adultery and/or significant other that may be involved in your spouse's life, that evidence may also be admissible, again, not to prove the grounds for divorce, but rather for some other purposes, such as child custody. In those situations, you may want to put in evidence that the adulterous relationship is an ongoing one, or your child has been exposed to a person who is not a fit and proper person to be in the presence of your child. Again, that evidence is admissible not because of to prove the irretrievable breakdown of the marriage, but rather to show that the person that your spouse is cheating with is around your children and potentially interfering in parental obligations, parental duties, or actually injecting themselves into your children's lives in an inappropriate manner. The next issue we want to explore is which is the best state for you to get divorced in? As we spoke about earlier, you can file for a divorce if either you or your spouse has lived in Florida for the 6 months preceding the filing of the action. However, as we discussed, no-fault divorce has an impact in Florida, and if you live out of state and moved to Florida, or your spouse lived outside of Florida and moved here, you may want to consider filing in a jurisdiction other than Florida where fault might be considered. Each state's divorce laws are drastically different, and that needs to be considered when you're dealing with a two-state situation. Also, you have to consider child custody issues, equitable distribution issues, and alimony issues. For example, if you moved to the state of Florida and lived here for 6 months, but your spouse still resides in the state that you were last resided together as husband and wife, Florida may not have jurisdiction to deal with issues such as child custody, alimony, the distribution of assets and debts, what we commonly refer to as equitable distribution, and other related issues. So it might be advantageous for you to consider filing out of state if that state's laws are going to be more favorable to you or give you jurisdiction to determine other issues. Simply because you moved to the state of Florida, for example, and your children still live in the originating state, Florida may not have jurisdiction to deal with child custody issues or child support issues or alimony issues or distribution of assets and debts because we have something called the Uniform Child Custody Jurisdiction Act, which basically defines the home state of a child as being the state where the child has lived for the 6 months preceding the filing of the action. So while you could conceivably get divorced in Florida, if your children didn't live in the state of Florida for the 6 months preceding the filing of the action, and thus Florida is not their home state, you could simply get divorced in Florida but not be able to deal with the other attendant issues. The same thing goes for alimony, equitable distribution, and other related matters. I recently litigated a case where the parties lived in West Virginia, and they owned a home here in Florida, just a vacation home. There's case after case after case in Florida that says that simply owning a vacation home in Florida does not subject you to the jurisdiction of Florida for purposes of alimony and equitable distribution. So for our friends from out of state, that is an important consideration. Another important consideration is that if jurisdiction is an issue, then your attorney nor you can make a formal notice of appearance in the action. A special notice of appearance needs to be filed, commonly referred to as a limited appearance, for the purposes of determining jurisdiction. Lastly, I wanted to talk about a common myth about divorces. A common myth is that you have to ask your spouse to give you a divorce. That's not the case here in Florida. If you want a divorce and the magic words come out of your mouth, my marriage is irretrievably broken, you are going to get a divorce. So you don't have to ask for it, you don't have to beg for it. It's something you're going to get if that's what you want. I hope this video has been informative, and if you have any questions, please feel free to give my office a call at area code 772-221-1922. Thank you.